We are on the record in the Manchester Family Division. It is Tuesday, February 12th, 2019, and this is case number 216-2004 DM 913. It's the matter of Margaret Criss and Roland Howe. And may I ask those of you in the courtroom to please identify yourselves for the record.
I am Margaret Criss, the petitioner,
Good morning.
Cameron Chris Chambers, son of Margaret Criss, the petitioner,
and sister of Brittany.
and brother of sister of Brenda Lee.
Well,
Good-
yeah, that's
Good
easy.
morning. And on the phone, sir, may I ask you to identify yourself, please?
I am Roland Howe, the respondent.
All right. And sir, at any point you cannot hear us, let us know. We'll try to adjust the phone so you're able to hear. We're scheduled this morning for a status conference, but as Ms. Criss just identified, there's sort of a preliminary issue we need to tackle, and that has to do with your CART interpreter. We got your request for a CART interpreter, and the clerk's office has been working hard to get a CART interpreter in place, but they weren't able to get a CART interpreter in place for today's hearing.
Okay.
So at the very outset here today, I need to ask you the question of whether you want to go forward without one, or whether you want to postpone the hearing to a time when we do have one.
If people would allow me to be able to hear everything and make it clear, I would be glad to proceed forward, because it's very hard to have to reschedule over and over again.
I understand.
We had to reschedule because Roland did not come last time.
I understand, and I saw that in the file, so I'm aware of that, ma'am.
Also, with the multiple times of him having to be voiceover, it's kind of hard to hear from the phone, mostly not necessarily your honor, but just hearing his responses from the phone and how he goes. That's mostly what the CART reporter was for, because
Okay.
unfortunately we had to do this several times.
Okay. All right, Mr. Howe, are you able to hear that conversation, sir?
Yeah.
Okay, so we don't have a CART interpreter in place, but Ms. Criss is indicating that she'd like to go forward as long as the hearing is something you can hear, as long as you can hear the conversation, ma'am. So I'll just say to all parties involved, if at any point you cannot hear one another, you can't hear testimony, or you can't hear me speaking, then please just get my attention, and we'll speak louder and adjust things if we can in the courtroom to make sure everyone can hear everything.
Thank you.
Thank you, Your Honor. I would also like everyone to be sworn in before we proceed.
That's my custom.
Okay,
That's my
it
custom.
hasn't been a custom in the past, so I wanted to address it.
Okay, all right. Well, we are here for a status conference. It's not really an evidentiary hearing, so I don't know how much testimony there'll be, but.
Well, the thing is that there has been orders written that these evidentiary hearings, numerous issues were supposed to be addressed that haven't been, dating back from December 5th. And I would like to know, if these aren't evidentiary hearings, when am I going to get the opportunity to present this evidence?
That's number 2 on my list of things to do
Yeah.
today. Okay?
Beautiful.
All right, so, Ms. Criss, I'm going to ask you to raise your right hand. Mr. Howe, I'm gonna use my imagination here, sir, and I'm gonna ask you to raise your right hand as well, okay?
Yeah.
All right, do you both swear that any testimony you provide to the court today will be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do, but I'm waiting to hear Roland's
So am
response.
I. Mr. Howe?
Yep,
Do you,
I
do do you so swear?
I do as well.
Yeah.
Okay, thank you. All right, you're welcome to have a seat if you'd like.
Thank you, Your Honor.
All right, so we're here for purposes of a status conference today, and I've reviewed the most recent portion of the file. It's a big file, so I've reviewed the most recent portion of it, and Judge Hall wrote an order in December, and she set out a roadmap, so to speak, for what the status conference was supposed to focus on. And there are really 2 things that she's identified that needed to be addressed. One of them was the status of therapeutic evaluation of Brandi Lee. That was one thing. And then the other thing that she had identified to address was, Mr. Howe providing a working phone number so that Ms. Chris can, speak to Brandy Lee by phone.
That still hasn't happened.
Okay. So those are the two issues that Judge Hall had identified, to be heard this morning. And then there are some other things, as I review the file, there are some other things to address as well.
Thank you.
So, Mr. Howe, I'm gonna turn to you first, sir, because it seemed like Judge Hall's order, had some follow-up tasks that you were to be working on. So I just wanna check in with you, sir, and talk about the first question that Judge Hall raised, which was the status of therapeutic evaluation of Brandy Lee. Has that moved forward at all?
We made, 2 attempts, since her first order, and what we had discovered was the particular counselor, the type of counselor that Brandy should need was a qualified counselor to dictate whether the child is old enough to make her own decision.
Your Honor, finally.
And it's very widespread and very difficult to find a particular counselor that actually counsels in that.
So is that a no?
Randy has been, two facilities, she went down through the questionnaire sheet, and it was my understanding it was supposed to be a counselor, not the corporate, but we had found out, discovered that Randy does not show any kind of illness to participate in that part of the counseling team.
So she's gone to, I'm sorry to interrupt, sir. Can I just ask,
Go ahead.
can I just ask, so you said she's filled out 2 questionnaires or two intake forms?
Yeah,
And were they at different, counseling offices or counselors', practices?
yeah, it's 2 different, facilities.
Okay, and so neither one of them led to identifying a counselor who could do this work?
No. We made attempts to call the local courts, out here in Indiana to find out if there was, any particular counselor that we can be guided to or Brandy to dictate whether she's able to make her own decision. We have not heard back from the court, and that was, last week, we put out a call, so.
Okay, and,
Not we, my wife did, because obviously I'm out on the road, so.
okay. And so the question that you were exploring was Brandy Lee's level of maturity?
Yeah.
Your Honor, may I interject
I don't
momentarily?
think a child needs to just be thrown in a counseling piece just because someone says she needs counseling. We're going back on the record, and Brandy Lee was, granted to go speak to the judge on her own behalf.
Yeah,
On what her insight and her decision choice making was. And the final result of that hearing was that, the judge had ordered for Brandy to go to a counseling piece because I actually recommended it at some point. And this is what we're discovering with, Brandy's, counseling piece. She has to show that there's different counseling session pieces for different individuals.
yep,
And she cannot go to a psychiatric facility for counseling because she don't show any signs of that. And that's what we're running into. She's not a victim of any kind of source of violence.
okay. All right, thank you, sir. I wanna hear from, Ms. Chris with respect to, this issue.
Okay, with respect to this issue, Judge Polly Hall has issued, court orders numerous times for Roland to get Brandy Lee into counseling. When she had the one-on-one in her chambers evaluation with Brandy Lee, she had said that she doesn't feel that Brandy Lee is mature enough to make her own decisions, which is why she advised for counseling. And this has been ordered numerous times since last year, I think up to 3 times now, where Roland had provided a name of Dr. Sean Wheel, that he had secured counseling for Brandy, and she issued a court order based on perjury because I spoke to Dr. Sean Wheel, and as a matter of fact, I sent a subpoena for him to come and testify, because I only had one conversation with him. Roland indicated to the court that I harassed this man so much that he refused to treat Brandy Lee, when in all actuality, I had one conversation with him, and he said he did not take state pay or high conflict cases, and he had never even heard of my daughter. Since then, Roland has denied numerous times he has been given ample opportunity. Since last year, he was ordered to get Brandy Lee counseling when he took off to Indiana.
Hold on, let me
Excuse me.
let me interject here real quick.
Yeah.
In accordance to Roland's answer just now, he had actually used the same verbatim answer with his indication that he was taking her to Dr. Sean Whelan. He did 2 different therapists, or although I think it was 3 last time, and he did the same thing where she took her for intake, and that was as far as it went. That's his answer almost every single time
Every
when it's
single
brought up
time,
for
and in the
therapy.
meantime, she's not getting that therapy that's been ordered numerous times. And I'm wondering why it is that the law doesn't apply to Roland Howe, because every time, he's in violation of every single order that's been written since last year, including leaving the state without notice. That's custodial interference, 42 US Code 1983. And I put a motion regarding that in on the 22nd of February in last year, and we're still going round in circles. Like, why doesn't the law apply to Roland Howe?
Sir, have you had an opportunity to hear that?
I had an opportunity to hear that, but obviously I have issues with that, but I will not go into that piece because it turns into being an argument at this time. I think that overall in the 15 years of the courts entertaining this case, I think they can come to the conclusion to themselves of what is really going on, okay? It's not about the child's best interest. It never was through this court, even through the higher court. And when it got switched over, the court decided that they're gonna entertain this, okay? I'm explaining to the court the reason why Brandy has not been provided for counseling. And the counseling session should be maintained on the subject of an issue mature enough. And we have not found that. What the petitioner and Cameron stated before the court, that's just all hearsay. That's what they.
It's not hearsay,
But I
it's
think
court
she
order.
will.
Let him say it. We have any documents, it's not here, so.
Okay, so let me ask you about your understanding of what is supposed to be evaluated. Your understanding is that Brandy Lee is supposed to be evaluated in terms of her maturity to make decisions about her contact with her mom?
Yeah.
Is that your understanding as well, Ms. Chris?
No, my understanding of having her go into counseling is for a whole range of emotional difficulties that she's having. Roland Howe is practicing domestic violence by proxy. He has always interfered with our relationship. So to the point of removing her from the state without notice to this court, to my attorney that I had on retainer at the time, or to myself, which has never been addressed. He just up and left. I wonder how it's in Brandy Lee's best interest when she lived her whole life in New Hampshire and never got to say goodbye even to her own family, and he just upstaked and moved. And he even said in open court here that the move was not for the child's best interest, it was before his employment opportunity. Now, he said he was struggling financially, which I find very hard to believe, because when somebody's struggling financially, they don't move several states away and purchase a $180,000 home with a swimming pool. That's very contradictive of him saying about his financial struggles. themselves.
But they're
You
asking
know, and
about-
Brandy was moved away from everything she's ever known and loved without benefit of closure to start over somewhere else for her father's reasons, and why I still don't have phone contact with her despite numerous court orders,
Mom.
and why I can't practice any kind of relationship with
Mom.
her.
Mom.
That is what I want to be addressed in counseling, as well as her inability to advocate for herself, which I just received in writing from her school at the IEP meeting,
No, social anxieties and.
is indicated.
Time out, I think your son was trying to get your attention.
Yeah, I was just trying to say, is make sure you bring up the education that we did just receive from her IEP meetings, that there were numerous social anxieties and, you know, not, like Roland had said, the ability to speak up for herself as well, but social anxieties that we felt have coming on from early childhood and that we were trying to address well before this court went back into session back in 2015. Like I said, this is probably the 5th time that we've brought up counseling, and maybe the 3rd time he's given the excuse of, we brought her in for intakes.
And also I wanted to address the fact that he said she's never been exposed to violence. That isn't true. I have a police report inside the case file of him choking and beating me with a 4-month-old Brandy Lee in my arms.
Well, that's 4 months, it's cognitive, she doesn't have that yet,
Okay.
unfortunately.
But if he's capable of it then, whatever changed? He never received counseling for himself.
I'm just saying.
So, Mr. Howell, let me ask
I don't
you.
know, it seems to be several topics thrown in this from the petitioner. Apparently, we're kind of like getting off track, but,
Well, I think that's true, but-
I express myself to this court. The petitioner has essentially, with her acts of her behavior, has essentially lost the life duration of her relationship with the child due to her own actions, not by the courts, not by me. And here we are still standing before the court, required to do all this kind of stuff, you know, in particular. I'm trying to address certain things and take a follow-up and doing what I'm supposed to be doing, but, you know, we're essentially getting to the case where, the situation where the case is eventually getting burnt out, okay? I think the courts need to recognize the whole package here.
Oh, I wish they would.
Okay.
I can't wait for him to read the entire case file.
What the petitioner is trying to state before the court about this IEP thing, that's another issue that needs to be handled, which I'll probably eventually file before the court, because it's my understanding, when you're a custodial parent, you are the one that's entitled, and only entitled to make the adjustment on the IEP. Well, the petitioner had got involved with that IEP meeting and tried to make accommodations and adjust the IEP. And it's become a furious thing out here in the state of Indiana with the mom. She is well recognized before the court, before the schools, as terrorizing everybody. It's so bad out here at the school district.
Does he have any evidence to back up those allegations? Because I don't appreciate them.
Counselor. And the lawyer for the school district is involved with this too.
Okay, well, I think that is an issue for another day. I wanna get back to the counseling question for just a moment. When you did the intakes with Brandy Lee at the 2 different counseling services, what was the nature of the service that you were requesting from them? Like, in other words, why did you tell the counseling service you were there?
I went in there for the intake, and they asked me why was she here, and Brandy had to fill out a questionnaire sheet on her active behaviors or any anxiety issues, and that has nothing to do with me, but Brandy was handed that form, and the doctor had came in and told me that she didn't meet the criteria for any of that counseling session, and I had asked the doctor why not? Because she's not a form of sexual violence. And she asked me what was the particular reason why I brought her in for any kind of counseling sessions. And I just told her basically I had a couple of litigation going on. And originally ordered for me to do this. And, we had made some other attempts, but the problem is that, I am the biological father, which I have to be there, at hand, to do the first couple sessions.
Okay. All right, I want to change gears for just a moment, because the other portion of Judge Hall's order mentions a working phone number, providing Ms. Chris with a working phone number so that she can speak to Brandy Lee by phone.
Well, what the petitioner has stated before this court, now you reported that she has no contact with the child, right?
I don't.
But she was provided a track phone number. That track phone, Brandy does not carry it with her 24/7. Okay? It is readily available to the child to pick up the phone call and talk to her mother on her phone. As her choice. Now, I can tell you that the petitioner is stalking us so much.
Here we
that
go
he's
again.
actually, every Wednesday they have late start. And the first week that we had it hooked up, I believe it was 3-4 weeks ago. The first week we had it hooked up, the petitioner discovered that the child's gonna go in for a late start. She had started calling that phone at 5:15 in the morning and ended up approximately about 8:30, 8:45 with about 42 phone calls. And my daughter's walking by the phone and just thinks that's just insane, you know, and I don't know what to do, but the child is provided with a phone, so, and this is what's been going on. Actually, the court order does state that the petitioner is to call on Sunday. The petitioner calls
She never answers, I don't know
like
what's wrong
habit
with it.
every day. If it's not every day, it's every other day, it's random.
No, he lies all the time.
So when you say 42 phone calls, you're saying between 5:15 a.m. and 8:30 a.m.?
8:45.
I wanna see that printout.
Yeah, I'd like to see that.
I'd love to see that.
This is kind of how the school's dealing with the petitioner too. I mean, we had issues with that, with the petitioner doing that anyway. She's done it with the local sheriff out there, she's doing it with the school. We provided with her a phone number, with a track phone, and we're getting that kind of issue with a track phone.
Did you mention that at one point, there was a scheduled time set up for the phone call? So has that worked?
Ordered for the petitioner to call on Sundays, I believe it was from 4 to 8. I could be wrong, but it was on Sundays.
So has that worked?
And she, no, the petitioner takes it upon herself to call like whenever she feels like that. And
We were granted permission to do that by Paulie Hall, to call whenever we feel like it.
Hold on, let me
very
interject.
strong will on the phone of who she is and what she is and her entitlement, and I don't think her active behaviors should not be ignored.
Okay, so thank you, sir. I want to hear from Ms. Chris on this.
I don't know whose phone that is, because I can never reach my daughter on that phone. I can't even leave a message, because when I call it, it says this phone number has a voicemail that has not been set up yet. I had 1 2-minute conversation on New Year's Eve with Brandy Lee.
When we were given the
And
number.
she hung up on me promptly, so when I called back, I told her if she did not wanna speak to me, that I would appreciate it if she would let me know verbally that she didn't wanna speak to me and not hang up in my ear, cause it gives me the impression that she's being raised to be rude, and that doesn't make me happy. I have not heard from her since. Yes, I have made numerous attempts to call my daughter. Polly Hall adjusted that initial court order for Sundays, which he also didn't comply with. There, last year on her birthday, there was a court order written for me to talk to her on her birthday, which he also did not comply with. Excuse me,
I know.
let me finish.
You're ranting a bit, just give me one moment, let me just sum it up. We did have the original order for Sunday. Unfortunately, we were having issues with Roland interjecting in between the calls, hovering over Brandy, and she would shut down halfway through. Also,
And he
the,
wasn't supposed to be in the
it
room.
was not, also there was an assorted time frame. We would call in between that time frame, the time wouldn't
Well, there
answer.
you go again,
Hold on, sir. Hold on, sir.
You had
Hold
your
on,
chance.
Hold on, sir,
That's just what they make assumptions.
sir, here's the scoop. We're on the record, and in order to create a good record, people can't talk over each other. So I've asked, Ms. Chris not to speak when you're speaking. I'm gonna ask you to extend the same courtesy, okay?
They
So-
were unfortunately not being met at the times. When she would call, the home phone number would not be answered, his personal cell would not be answered. Now, when we were given this track phone number, which I believe was what, January?
It was on New Year's Eve.
New Year's Eve. That was the only time my mother spoke with her, and then I spoke with her. I called her right afterwards. I've called my sister twice since then because Judge Polly Hall did allow it that I was able to call as well. I've called her twice. I get the same no answering machine available. I asked my sister if text was available. She said she didn't believe so, but I have texted her twice just to say, hey, a happy birthday, which is in January. And then we recently got her school photos. It was, hey, beautiful photo. I hope you're doing well in school. Now, I would love to see a printout transcript that said my mother called 45 times between 5 a.m. and 8:45 a.m. with a child. She's not even up at that time, so I would love to see that transcript of those calls. I'll admit my mother's probably called a few times trying to get hold of my sister to see if it works. Now there's no answer at the phone. As far as his accusations of the school, my mother calls the school for regular updates on my sister and to make sure that meetings are being attended for her IEP, which Roland does not attend, his wife does, who has
Who has any kind of custodial rights of my daughter.
And as far as the sheriff's department, like he mentioned, we were calling the sheriff to make sure he was formally served because he was denying documents that we were serving to him from the court. He was denying it from the sheriff's office, so we were calling the sheriffs to have those things personally served to him, which he would still deny. So it's not that we were harassing sheriffs, we were trying to get the court's orders done through the best way possible that we were able to do.
I'd also like to address the misrepresentation that he said that I have a bad relationship with the school. I had to file a federal FERPA complaint to be even involved in her IEP meetings because Roland and his wife forged documents and wrote her as her biological mother. I had to send everything but a DNA sample to that school to prove that I am her biological mother. I have full parental rights. They've never been terminated. Roland and his wife are the biggest obstacles in me exercising those parental rights, as well as officers of this court who has been dragging this out since 2004 while I lose my rights little by little to no contact at all, which is where I am now.
Also, we've had no access to her we've gotten them now since then, but during her time in elementary and middle school, we had no access to her school
And I
because
have
of that.
those records of his wife's forgery, and she's forged medical documents too. And there's a court order stating that I am supposed to be informed of everything that happens at school, everything that happens medically that has not happened since she was 4 months old, and it's still not being addressed.
Also, if she'd been such a big problem as far as harassing schools and everything, this issue would have shown itself in elementary and middle school days because he kept us away from her and kept us completely out of her life other than a visitation center for 10 years. Then I think these issues would have shown themselves more promptly in the beginning. But now,
And
because we're
there's
fighting
laws
for...
against what he's doing, and they're not being enforced.
Okay. Mr. Howe, anything that you want to say in response, sir, because we need to move on to the next topic?
No, it was just go round and round. I think the paper trail essentially sets the standards for this court of what's really going on with this case, with whether, it's safe to move on with this case or not. I mean, the child has never had the opportunity to develop any kind of relationship with the petitioner due to her own actions. I mean, she's been given ample opportunity through the courts, myself, and that's proven on record for her to build a relationship with a child. Essentially, the child does not know her, and it's due to her own actions.
That's not true, Your Honor, and I'd like you to review the whole case file to prove that.
Don't interrupt.
What am I to do? What is the court to do? I mean, the child does have a track phone, and it's her right and opportunity to pick up that phone and call her. But it's also her right not to talk to her.
He encourages no contact.
Okay.
When she goes to school, she can say, I don't have to talk to a friend. That's her choice. She's old enough to do that.
Okay. helpful in terms of helping me understand kind of the current setting for where Brandy Lee is and where a couple of these issues stand. We need to move on to the next topic, and that is there are a number of pending motions. I'm not going to read them all, read the titles of them all, but there are a number of pending motions that have been filed, including, I think one as recently as the other day. There was one filed on February 4th. So there are a number of pending motions, and I think it's appropriate to schedule a motion hearing.
Love that.
I think an hour is probably
Yeah.
needed because there are so many. So I'm gonna ask, can we look for an hour-long slot, please?
Yep.
Your Honor, on 5/18/18, I filed a motion, that was last year, for Roland to comply with the mandatory disclosure law. He has not provided this court with a financial affidavit since 2006 in direct violation of the mandatory disclosure law. And he has also in open court refused to do so. And I would like to recommend that he have to comply with this mandatory law, as I already have done so numerous times, and he has not.
Okay, I haven't looked back in the file far enough to know if that motion was acted on. Is that one of the pending?
It was
motions?
never acted on. Polly Hall insisted that there's no financial matters before the court, but the problem is that Roland moved, he purchased property, he declared bankruptcy twice. That should have been reevaluated right away, that he was not financially able to take care of Brandy Lee, and this has never been evaluated, and he actually refused to provide that information in open court when Polly Hall was presiding, and I'd like to know what part of mandatory disclosure does not apply to Roland Howe.
Okay, and I appreciate your argument, ma'am. I was going to ask the same question that Judge Hall apparently did, and that is, are there financial issues before the court?
Yes, there absolutely is. Roland says every time Brandy Lee's ordered to go to counseling, or even when Judge Polly Hall ordered a guardian ad litem, he refused to pay for it, saying that he had 6 kids and he can't pay for it. Well, if he cannot pay for a guardian for Brandy, if he cannot pay for counseling for Brandy, then why does he still have Brandy?
Also, when they first moved down there and she was put into the school indicated she had no health insurance. We haven't seen any evidence of health insurance since then.
And not only that, he didn't even show up last time, and I put in a motion for a default judgment, and instead it was rescheduled, so I'd like to know where the evidence is as to why he couldn't attend last time.
Well, according to the order, there was a weather-related delay. He was.
So we're just taking his word on it when I already have proof of perjury twice?
Can we look
Don't
at
get cross with him. It's not his fault. Okay.
60 to 90.
60 to 90, okay, so that would be, let's see, 60 days would be. Oh, wait a minute.
Because I'm required to provide evidence of everything that I say, but he hasn't provided any evidence of anything. Even his moving to Indiana, he was supposed to prove to the court that that was in the best interest of the child. There's no evidence proving that, but I'm supposed to, it's the burden of proof is now on me to prove why it's not, which I have tried to on numerous occasions. And I would like the equal protection under the law to apply to both of us.
That was the first order that Polly Hall issued when it was discovered that he moved without
I read it.
reason. Yeah, and again, that was never proven, never given. Originally, actually have it on video, that he was given a 30-day notice, and that was, I believe, the May hearing. And then when we went back to court in July, he still had not provided anything, and there was no consequence, even though there was a 30-day limit put on it.
And I mean, I think this case should be taken into consideration as a whole, and read the entire, I know it's a huge case file, but since 2004, my rights to be a parent to this child have been violated over and over and over again. That guardian that Polly Hall tried to assign was the 5th in this case, and they have failed her over and over and over again.
Also,
And I mean, this case file is huge, but it shows a pattern of Roland totally preventing me from being her parent, and it has not been addressed, and it's still not addressed today. And it's gotten to the point where we don't even have a relationship at all. And it's not because of my behavior, it is definitely because of Roland and his wife. And I also have medical records that I could submit that she signed as Brandy Lee's mother when there is a standing court order for me to be notified of any medical procedure, which has never been done.
Okay.
And Denise is looking for a date from you, Judge, so it's good.
For an hour long?
Yeah.
Okay. Okay, while we come up with that date, let me ask this question of Mr. Howe. Mr. Howe, what is your assessment of Brandy Lee's level of maturity? She's 15.
Good.
So tell me what your assessment is.
About Randy's, maturity level,
Yep.
as far as her dictates on, safe measures for the day, or?
Well,
She's, basically developed into a very young woman. She's very responsible. And, as far as, her willingness and drive to get up every day to go to school. If she was told she can't go to school for doctor's appointment, she freaks out. She's a very responsible woman, and, there's some things even adults go through where you're blindsided by things, but she's very observant, she's very passive and reserved. She's not impulsive like a lot of girls are 15 years old. She's essentially really responsible around the house. I mean, she comes home every day, and it's mandated in our house for an hour and a half of homework time. She is informed and compliant with that. She comes home every day, and that's one of her motives, was to get her educational piece done. I mean, I
okay,
don't know how much more I can explain to the court on her maturity level, but,
okay. I think that
I
answers,
can tell you, personally myself, I would rather have her than a lot of 15-year-old girls out there. She's never showed any acts of violence whatsoever. She gets
Violence have to do with
all right, sir, thank you. I think that answers my question. Thank you.
Your Honor, in contradiction of that, I mean, even when the judge had Brandy Lee come into chambers with her 15-year-old girl required a stuffed animal to even speak.
For emotional security.
And a
And
parent-
also on her IEP, it says that she has social anxiety.
Emotionally
And she
stunted.
cannot be put on the spot. If you send her up to the blackboard, she shuts down. She has to have physical cues rather than verbal cues in order to perform in school. And I will be submitting a copy of that IEP report to this court.
Okay.
Also,
Thank you.
when we were visiting with my sister, I mean, again, it took her, within the first like half hour of the visit to really kind of open up and, kind of come out of the shell, kind of tell us about her day, tell us about what's going on at school. She was restricted from talking about certain subjects such as home life and all that. And due to that, the only thing she would really open up about is, she was kind of kept at the level where she was monitor of her younger siblings, but when it was, some kid did something wrong in the family, everyone was kind of group punished together. So she's kind of kept at a little bit of a stunted maturity from what we've seen as far as the IEP and from what the court told us and what we were kind of learning from her as she was getting older in the visitation center, was that she was kind of kept at the level of her siblings who were all 4 or 5
Much
years
younger.
younger than her, or up to 10 years, some of them, and she was just kind of held at that. Not to mention, when we first started coming back to court, Roland's stepwife and himself had stated in open court that, they don't allow media or, computers and all that. I think she was around 10 or 11 at this time. I'm sure she kind of has more access now being in high school, but she was very stunted as far as what she was allowed to do, which again happens in some religious homes and all that. I'm not acknowledging it doesn't happen around the world, but it does stunt the social maturity of some teenagers in today's world.
And I have had conversations when I was still allowed to talk to her on the phone. And when she talks about any of her family members, Roland screams in the background, "This is your phone call. You talk about you. I don't want her," meaning me, knowing about my family. And she gets so nervous that she shuts down and the phone call ends because he's constantly helicoptering in the background, screaming at her for supposedly supplying me with information about his family. So he dictates what she's allowed to talk about and what she's not allowed to talk about, which resulted in her not speaking at all.
This maturity is only leveled by what he allows and what he says.
Okay. All right, we're gonna have to leave it there for now. We've found an hour-long slot, for purposes of, a motion hearing. It's May 7th at 11 a.m., so ma'am, this is gonna be your notice, thank you. Mr. Howe, we'll send your notice out in the mail, okay?
Oh, Your Honor, there's one thing that while I have Roland's attention, I would like to address as well. He put in a motion to the court that I was not sending him copies of court orders, and I was actually threatened with a sanction by Judge Kimberly Shabbat for not sending him copies. I mail him copies of all court orders, certified mail, and he refuses to pick them up. So he can't have it both ways. Either he's going to accept the motions that I mail him, or don't cry about it and get me sanctioned when you supposedly don't get them when I always send them, and then not pick them up. The same thing when I mail Brandy gifts, he doesn't pick them up. I had to pay $100 in postage to mail it out, and another $40 to pick it up when he sent it back. I have a court order stating that I can send cards, I can send letters, I can't do any of that.
Also court interrogatories he sends back as well.
Okay,
Unopened.
so, sir, under court rules, every litigant has to send a copy when a motion is filed or an objection, anything that's filed with the court, a copy has to be sent to the opposing party under court rules. Are you aware of that?
He asked for it, he's very aware of
But
it.
it's the court that allows the petitioner to do whatever she feels like, okay? She said she will go in there and she will file all these motions as you've explained them and trying to do the proper procedures. Now, on each one of those motions, it does state that I am entitled to that copy. What is not going on is she's not actually following the court's rules because she will not send me that piece of paper.
I have a whole pile of them returned to me.
We have
Okay?
mountain stacks of him returning evidence.
I don't need 500 pages,
Could you please give this to
Sir.
Your Honor there's just a sample of some of the certified that I've sent.
I'm not reading 500 pieces of paper that she hung on to and cried before this court how much money she paid to defend them, okay? I have within 10 days of responding to every motion. It's my understanding that's the court's rule. I don't get that opportunity. I never have.
Why not?
Because you don't spend them. I have within 10 days.
I'm certified.
That's just a sample, we have bags.
I'll bring them all to the next hearing, a whole pile of them that he returned.
In 3 months, and then sends a whole big book to me. I don't have that opportunity to sit here for hours to go through 500 pages of bookwork, you know?
Okay. All right,
Each motion, both sides is allowed within 10 days to respond to a motion,
Right.
okay? The petitioner does not follow those rules.
That's not.
okay. We're gonna have to leave it there for now. We're over time, and I have another hearing that was supposed to have started 20 minutes ago, so,
Thank you.
we need to conclude the hearing for today. The next hearing is, May 7th, at 11 on pending motions, and Mr. Howe, you'll get your notice of the hearing in the mail, okay?
Okay?
All right, thank you all,
Thank you, sir.
thank you.
Okay.
And Mr. Howe, we're gonna disconnect now, okay?
Okay.
Thank you, bye-bye.